Educate, entertain, enjoy.
You're listening to Aspen Waite Radio.
Paul Waite.
I am Paul Waite, and this is Aspen Waite Radio. This is the Monday Aspen Waite Radio Breakfast Show. And our special guest today, sitting in a rather lovely room, actually, is Martin Holdsworth. Hello, Martin.
Good morning, Martin. Oh, no, I'm Martin. You're Drew.
I'm Paul, yeah.
I have to say, the problem is with these Zoom calls, I don't know where you find them. They're fantastic, but I invariably look and my name's there written in front of me. So the good news, you can't get any names wrong. Yeah, I'm fine. I'm great. Thank you. No, it's not, unfortunately. It's we're based in Harrogate, and this is a converted old mill building. So it's, it's very pretty. And the Wi-Fi is a damn sight better than it is at my house. So I'm here most days.
Do you live locally?
I do, yes. We're I've been born and bred in Yorkshire, so I'm live in a little town called Wetherby, which is sort of stuck halfway between.
I know where Wetherby is because I'm a big horse racing fan.
Oh, well, you will do then. In fact, you'll know as well. It's exactly halfway. Its claim to fame is it's exactly halfway between London and Edinburgh. So it's 200 miles north, 200 miles south.
Is that right?
So
I didn't know that.
It's literally right bang in the middle. So, in fact, I don't live far away from the race course at all. So, you know exactly where I am. But where I'm sitting now is Harrogate, which is a little bit further north, with a very nice view, with Betties and Fat Rascals and all kinds of things over here. So can't complain.
Yes, that's actually prompted me. So one of my best friends in the world is a guy called Dean Robinson, who is now the sales director of a quoted company in Australia. And he was born in Harrogate about 62 years ago. And it's definitely, if I had to get drunk with a person today, I would definitely do it with Dean. Absolute legend of a man, and son of Harrogate.
I have to say, Joe, he's 62 years. It will not have changed at all. It will not have changed at all. It's exactly.
I think Martin thinks you're me.
Yeah, again, I've got the names underneath, so I'm gonna ignore the names and look at the faces. We normally have Zoom meetings. We've got about 12 people on the actual calls, so we have to follow the names.
Yeah. Anyway, so I was saying, I don't know if you were listening to the sort of preamble, that I might be in danger of talking to a lawyer that's actually quite interesting with a personality.
I'll do my best.
I think that's true. Or was that an overstatement?
I suspect I embarrass my children, so I suspect that's probably a good guide. Is that I'm fortunate that I deal with an area of work that is fairly interesting in the sense that it deals with all manner of family issues and problems, and you have to keep it light because it's fairly dark at times. So we try and do that. But yes, certainly so far as I'm concerned, it's an area of work that I've really enjoyed.
Yeah, so I think it's an interesting one today. As I say, this is the first time I've actually spoken to Martin at all. So I know a bit about him, and he was introduced by my great chum, Sandro. So as I said earlier, if Sandro says Martin's okay, then he's okay by me. So normally we start off sort of ABC, but I think probably today, given what Martin does, and I think it's an incredibly important area, it might be worth sort of starting off sort of at the beginning and then going backwards, if you like, doing if we were a film, I think we're gonna have flashbacks. I think that's the way of putting today's interview. So Martin is an expert in what is called contentious probate work. So for the uninitiated, tell listeners what that means.
Yes, contentious probate, as opposed to non-contentious probate, is essentially that's about as far as you get. What it essentially means is that when people die, obviously what happens is their estates are administered, and they're administered in a certain particular process. It's non-contentious. People get a grant of probate, gather in the estates, and pay it out. What of course happens in some estates is that there are disputes and there are problems, there are claims, there are issues. And that whole range of problems and disputes and issues is exactly what we do. So we get involved and try and resolve and settle those problems to allow people to then finish off the non-contentious probate administration work. So essentially it's families who are fighting following a death that we try and get their problems fixed as quickly and as cheaply and as painlessly as possible, really. So it's an area of work that's building. There's absolutely no doubt about that. I started on my own 4 years ago. We're now a staff of 15, so to give you some idea of how much of this is actually going on.
Okay, so I think we'll I just wanted people to understand, what you were doing, and I think it is an incredibly significant issue, and we'll talk about that as we build through the interview. So so little Martin was born in Yorkshire. Whereabouts exactly?
I was born in Leeds, so I'm still
Leeds.
a Leeds United ardent fan.
Sad.
Yes. Not at the moment. It has had its sad times, I have to say, but at the moment we're quite pleased. Everybody loves Leeds, apart from obviously yourself, Paul. So I was born in Leeds, stayed here, didn't go very far from Leeds, ended up studying my last year of my degree in Leeds. I flunked my A levels, to be completely honest. I worked very hard and then flunked them for various reasons, and decided to resit, but in the process of resitting managed to find a job at a local law firm, actually driving the trainee solicitor that was there around backwards and forwards to court. And that's how it started for me. No, that was it. And I decided at that stage I'm going to do a law degree, because I actually enjoyed...
So that's what you did?
Yeah. So I decided then to go off and do a law degree, but then started continuing to work with her, driving around and getting a real feel for law, really enjoying... Well, she was a family divorce lawyer, and just to see what she did with family members coming in and coming in bowed and worried and distressed, and being able to take that and give somebody direction and help and move out, I just thought it was amazing and really enjoyed it. Yeah, she's a great character, and unfortunately she's passed away since that, but she was amazing. And that really spurred me on to, actually, I want to do this. So I decided to do a law degree, worked through every holiday, every Christmas, every Easter, and then started with that very firm as soon as the day I finished my degree, and was there 11 years. Loved it.
Yeah, I have to come back to your point about your mentor, or wherever she was. The inspiration got you into law. My experience, which is quite considerable, of working with divorce lawyers, is not anything near yours. I have to say that, in my opinion, as I said, this is based on being involved in one way or another in sort of protracted disputes between husbands and wives, etc. A lot of lawyers are like ambulance chasers. Basically their whole policy seems to be to embark on a destructive strategy to maximise fees for themselves. Do you think that's fair or unfair in your experience?
Well, that's certainly your experience from the sound of it, Paul, is that I think it's everybody has an experience to tell when they get through divorce. I think what's absolutely clear is that, and it's a little bit like contentious probate actually, is that you're going to lawyers at a very sort of vulnerable, very upsetting, very distressing time, both emotionally and financially. So feelings are heightened. So there's a lot of responsibility on family lawyers and contentious probate lawyers to treat that and deal with people appropriately. I have heard those stories insofar as, and that feeling is something that comes out from the public. I have to say, the reason why Alison, she was called, was so inspiring for me is that she was exactly the opposite of that. Is that she was somebody who talked people into a resolution. She's ahead of her time, because we've now moved towards far more mediation than litigation. So they're talking about resolving stuff through discussion, negotiation, using a mediator to facilitate, whereas courts tend to be sort of black and white decisions, judgments made. So she was ahead of her time in that sense, is that she was really helpful to families, would talk about both sides of the problem, not back away from a fight when she needed to fight, but pick and choose when the right time was. So yes, there are some experiences as you describe. I'm certainly not going to try and defend that. But what I would say is there's a lot of good family lawyers out there who have a totally different view on it. And I have to say, there's more of those now than there ever were. I was talking about back when I was sort of 21, so I was 51 now, so it's 30 years ahead. Now there's far more of it. And in fact, the courts push people towards that kind of mediatory approach. But you can't take away the pain and the suffering. That's the problem. That's the consistent theme, isn't it, all the way through? That hasn't changed in 30 years. Yeah,
I guess there's actually a sort of a correlation between divorce work and what you do now. Similar sort of battleground, isn't it?
It is. It's the same cast members, isn't it? Think about it. Except in my case, the best witness is always dead. Because you want to find out what the person who's died leaving or not leaving something behind has actually helped. Whereas in a divorce, at least, there's two. And the other aspect to it, of course, is with a divorce, there's one singular pot that two people have to divide. So that's always painful, however you do it. Whereas with a contentious probate dispute, invariably there's an estate. We're all worth more dead than we are alive usually. So there's usually an estate that's then divided between people who didn't have or didn't need that wealth. So as a result, it can be a little bit more litigious perhaps than a family case. But you're right, the dynamics are very similar in terms of personality, feeling, angst, worry, and upset. So you're absolutely right. In fact, no surprise, I qualified as a divorce lawyer. The first thing I did, I followed in her footsteps for the first 2 years of my career, and then I was ambitious, young Martin, so I was quite keen to actually move on and do something a little bit more commercially successful. So I went into sort of harder nosed litigation, and then found my way into contentious probate probably about 15, 16 years ago now. So yeah, so it gives you some idea. It was for me a smoothless transition from divorce lawyer to contentious probate lawyer. Okay.
So I had to study a fair degree of law in my degree. Only was it company law, contract law, and English legal systems were things I had to take. So I do consider my company law to be quite acceptable. So when you take a law degree, are all law degrees the same, or do you have certain law degrees which are more, sort of say litigation centred or company law centred, which is more true?
It's a really good question. I think the short answer is a law degree is a law degree. You'll get different ones at different establishments with different modules, but invariably there are some basic things that you need to learn, and you describe a good few of them actually is the contract, tort, that type of stuff. So you'll always go through that. You'll get add-ons, law with French. My wife did law with business studies, trying to put it, and I have to say personally, anything that lifts what is quite a dry subject. I struggled with it as a subject because I just found it very dry when I was interested in people and commerciality, really, is that if you can lift that and then put that into some other kind of area where you can learn a little bit more about people, about how business works, that type of thing, then it certainly improves. Again, the world is changing insofar as qualifying for a lawyer. The Law Society and the SRA have introduced new ways in which you can qualify. So you can go through almost virtually like apprenticeships now, sort of on the job all the way through if you want to. You can start doing that from straight after when you're 18, actually, straight after your A-levels. So there is definitely a move away from you just have to do this dry subjective law, and then sort of 3-4 years down the line, we'll teach you about the other stuff that you really need to know about running businesses and dealing with people. So there is a shift, and I would certainly encourage people. We here have a mixture between bringing in very experienced lawyers who've already done it with junior paralegals who are just in about doing degrees, but then trying to teach them the real business.
That's interesting. It's being a bit sad at the moment. One of the things I don't know what this says about my brain is I've always enjoyed actual cases. So and the way my brain works, I've actually been able to remember some of them since I was probably 18 or something. So things like Foss and Harbottle, Donahue and Stevenson, Ebrahimi and Westbourne Galleries. And I do actually, I especially the Ebrahimi and Westbourne Galleries was all about the oppression of a minority shareholder. Are you able to remember cases? Is that something that you can do? Is it relevant?
I was having flashbacks then, Paul. Those are some good cases. Yeah, they're very famous ones, aren't they? You repeat and going back. Do I remember cases? Yeah. I mean, the way in which law works, as you remember, is that it's a combination of statutes, so rules of parliament being laid down together with then case law, which then helps us interpret what those rules are and create their own common law duties as well. So yeah, the law doesn't stop; it keeps on moving. And with contentious probate, particularly, is that it's a lovely mix from the lawyer side of me because there's this. It's moving in the right direction because the Wills Act, can you believe, is 1837. So the Wills Act has been around for a long, long time, and that still is absolutely good law in respect of how you can execute a will, how you create a will, what makes it legal, what makes it not legal. And then you've got a whole series of cases that then start kicking in to try and help us understand and interpret that. I mean, the law is really has to catch up, to be honest, still. It's 1975 when the next act came in that actually allowed people to bring claims against the state. So that's only been around 40 years. It's not exactly fast, is it? But we're getting there. I
have to jump in at this point again with some degree of knowledge, which is rare for me on any day. So the Partnership Act, I think, is the most hilarious. I think I'm right in saying it's 1891, if I remember rightly.
I think I think give plus or minus a year. I think you're bang on there, Paul.
I think it's like the 1891 Partnership Act, which I've actually read all the way through several times, because I've been involved in, obviously, as a I suppose a problem solver type sort of advisor that I would say I was. I'm the sort of person that I think actually the ability to solve a problem is more important than your specific knowledge, may I say. And so I've been involved in things like partnership disputes, and then to find that the law which is basically enshrining that dispute is over 100 years old is quite something. And of course, it wasn't fit for purpose.
Yeah, no, I don't disagree. I think you picked a good one, actually, because the Partnership Act is, as you know, only kicks in usually if there's no actual partnership deed or contract between the partners. Yeah. So as a result, it is all down to common sense and interpretation. And what you would say is you need bang heads together and get this sorted. And that's why you'll succeed at doing it, because it really is an old act that catches the situation where there's no contracts in place. But surprise, surprise, a bit like wills, most partnerships, I would suggest, don't have any formal contracts in place. They just carry on working together in business with a profit in mind, don't they? And so from my point of view, it doesn't surprise me that you're able to involve yourself in that kind of work with a common sense head and sort of drive down some sensible solutions at the end of it. I mean, a classic example for us on death, on the partnership stuff, is farming. You can imagine that farming families, and as a general rule of thumb, they work in a way that enables them to take advantage quite properly of single farm payments, that type of kind of benefits. So they do create partnerships at times to take advantage of that, but very, very rarely codify it in any kind of way. So then you're left on the death of the senior individual of a farming family, trying to resolve what on earth was going on here. Was there a legal partnership? Was there not a legal partnership? If it was, what were the terms? And you're back to that very act that you're talking about, is that well, let's go back to basics. Let's go back to the statute and come forward from there. So, but again, what it does is highlight to me, Paul, is this problem of people not taking steps to codify or to agree and put in writing things that they would like to have happen if things go wrong, whether that's a partnership splitting or death. And that's the recurring theme, isn't it? Is that people need it, but people tend not to go there.
But maybe one of the things we can talk about after your first track is why is it that individuals and businesses do not put in place the simple, basic ingredients, legal agreements that they should to protect them? So that might be something to do. Anyway, So young Martin, did young Martin like his drink and boogieing around? Are you boogieing around, or are you a northern man that doesn't do that sort of thing? Which is more true?
I suspect I don't want to sort of move away from my northern roots, but I suspect I'm probably more the former than the latter, to be honest, Paul. I'm the last one on the dance floor usually. So yes.
Yeah, good.
Although not to my first track, I hasten to add, but yeah, I usually am.
So music's been important to you all your life, or
I've enjoyed it. That's probably the way to describe it. I've got friends who know everything about everything. I do invariably hear something and go, I quite like this, and then we play it again. But I'm teased incessantly because I play music here in the office sometimes if there's only 2 or 3 of us, and the playlists keep coming back and it's the same people over and over again. So I clearly have a taste, but I'm not quite sure what that is.
Okay, so your first track today is by the legendary Nina Simone. So what does this track mean to you?
It was introduced to me by my wife, actually, and it was something that popped up time and time again in our life. We've been together 21 years plus, and we've had to deal with, like most families, I suspect, with family deaths and serious heart surgeries, and my wife had a stroke, and all kinds of things happened. And we kept coming back to this track because it just reminded us that no matter what was going on, is that the sun will rise, it will pass, it will come again. And that kind of held quite a special place to it. So every time this comes on, we're taken back to a sort of positive dawn after a difficult phase. So it's stuck with us. So it's certainly one of the tracks that I really enjoy listening to.
Okay, beautifully presented, Martin.
Aspen Waite Radio. Full Waite.
That was Nina Simone and her version of Here Comes the Sun, obviously the famous Beatles song, chosen by my special guest today, Martin Holdsworth, a true man of Yorkshire, sitting in his very lovely room with a nice orange chair behind him. So I hope you're having a lovely time, whatever you're doing in this hot, sunny Monday morning. Before we talk about why people are so badly organised, I think will be a thing to talk about. I'm quite interested about your career in litigation. I'm quite interested in law. So, were you a nasty litigator, or were you the guy litigating or defending against litigation, or both?
I mean, litigation, I did both in the sense that I was dealing with claims and defending claims. So worked on both sides. I didn't pick a side, as it were. I think my approach coming out of family law into litigation tended to be a kind of mediatory nature. I lasted about 5 or 6 years doing that, predominantly with nothing else. It taught me how to deal with aggressive litigation, because you did find that true civil litigation disputes about I did trademark disputes and patent disputes and corporate commercial disputes and a few minority shareholder disputes that you talked about. It's pretty hard nosed, to be honest, boys. Is that there's not much love lost invariably, and my personal view of that or experience of that is I in the end found it quite soulless, in the sense that the corporates had the money to fight the litigation, having come from a family kind of dispute background. Wow, there was an end in mind, to try and move people on. There wasn't always that feeling within corporate litigation. It was just very, very aggressive, and if it didn't work, you closed the company down. So it never really attracted me. And I moved out of it sort of 6-7 years later. But I learned a lot. I learned how to deal with that aggression coming in and out, where the civil procedure rules are quoted at you every 30 seconds. And it was a game to some extent. Some people love it.
You've done some good prompts today, so I must have paid you there. I want to tell a personal story. Probably the most stressful thing I've been involved in myself in my working lifetime is I took on a salaried partner many years ago, and probably the kindest thing I can say is that she never turned up for work, if you know what I mean. The person I interviewed never turned up for work. And there were sort of drink, family issues, etc. And what was so annoying about this is I did employ the best legal advice in terms of how to deal with this situation. This lady was invited to a legal meeting, and basically after about 10 minutes ran out crying, never came back to work again. About a year later, we get a letter from a solicitor basically saying that she was in fact a full-blown partner. Okay, she wasn't just a salary partner; she was in fact a partner. And then it was actually you believe it because you're a lawyer, but I think most people just wouldn't believe this. And then this thing then carried on, I think, for 7 years, right, from the start of the first letter to the end. Including a period of, I think it was 3 years where nothing happened at all. And I remember my lawyer actually phoning me up one day and saying, "Paul, you've won. This is ended, And I remember saying to him, anyway, I've got to tell you said about the game, so I've got to tell a story. So I was present at a mediation meeting. So we were basically, everyone had decided that it would be a sensible thing to try to mediate. So we had a very nice mediator, actually, who was very, very kind to me, especially afterwards when the lady did what she did. So we turned up in Bristol. I think it might have been 8:30 in the morning. And my lawyer and I sat in one room. The lady and her lawyer sat in another room. And the mediator, basically, as you know, walked in and out of both. And this is literally what happened, right? So the mediator starts off with her side. And he walks in. I can't remember the exact number. It might have been more than this, but he basically said she wants 240. It was either 240 or 340,000. I can't remember. And my lawyer, who I have to say, I didn't especially like him as a man, but you couldn't not admire his ability from looking after me. He looked at the mediator with no humour at all, and he said 12,116. That was his. So he walks in and says they want 240,000, and he says 12,116. Then this carries on, and it's probably one of the most. It's funny they say about mediation that you end up both parties end up so completely shell shocked that everyone thinks they've lost, and and it was quite incredible. By about 6 o'clock in the 6 o'clock p.m. after 9.5 hours of this, I probably would have agreed to anything. To be honest, you're just completely done in. But what was quite amusing in terms of passing on to the listeners. So after about 9.5 hours of the mediator, obviously the mediator went back and said, "Oh, Waite's lawyer has said 12,116." By the time we got to 6 o'clock, I think she was still, at some number like 200,000 or something. And we increased our 12,000 to 17,000, I think it was. And then she cracked, and I can't remember what time. About 8 o'clock it was, 8 o'clock in the evening. Yeah. And apparently this had never. Be interesting to hear your experiences on this. She ran out of the building, never came back. And apparently this was considered to be like heresy. You just didn't do this. And that's why I say the mediator, probably wouldn't have done this normally if things had planned out as they should have done. He came in and he had quite a, balanced conversation with me and said, look, if this goes to court, you're a very decent man. You're obviously telling the truth, blah, 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 blah. This woman's not engaged in the process. Blah, blah, blah. Anyway, so after that, she disengaged from the process, and then so we had 3 whole years of nothing happening at all, and then it came back, and I actually thought, and so she actually petitioned the High Court and everything, had a summons served on me, and literally right at the last minute, I think there was 2 days to go in the notice period, before it would have become, I would have been there standing in London or whatever. I made her an offer, bearing in mind that she technically owned a part of a building as well. So actually, I think if you took away her share of the building, it was an offer of less than about 10 grand. And blow me down, she accepted it. So, terrible. So that's what I think is a bit sad about that one. We're talking about people not taking advice. Is obviously, I did everything I could to take the best advice, and I still ended up with this horrific experience, which has scarred me for life, to be honest.
Yeah, that sounds as bad as it gets, to be honest, Paul. I think to go through a mediation, see it fail, and then for whatever reason, and then end up all the way through the very thing you're trying to avoid with a mediation is a double whammy. I think just a couple of comments in response is so far as mediations are concerned, I've probably been involved in well over 150 over the years, and in terms of success rates, I can count on one hand the number that have failed. So really? In that sense, it's a really high success rate. Now, bearing in mind the nature of the work we do, it's families together, pretty hostile. They're hard days, Paul. What you describe in terms of a length of a day is not unusual. Is that the average time to actually, for me, I arrive at 9:30 in the morning, and I won't leave normally till about 6:30, 7 on average. We've had some go right through to 2 in the morning. There's been some where I've actually had to go, as you've described, we're going to have to stop right now because my client can't even stay awake, never mind give me sensible instructions. So as a concept, it works really well. And the main reason for that is, I don't know what your experiences was with a particular lady that was on the other side of the dispute, is that very often the dispute's not as framed within strict legal terms, is that you might, to solve something, you've got to find a little bit of common ground, and the common ground might be 200 yards to the left or 400 yards to the right, but at least if you can find it and then work your way back from that common ground, you've got a better chance, I find, of successfully getting a resolution. And the problem with litigation is that you never get that common ground because the court sets very clear lines as to what this dispute is about and makes judgments based on those questions that it's posed. So it's always messy, and it tends to be the fear of a trial or the result of a trial is what prompts the settlement of the court door. There's no surprise that lots of trials settle at the court door for that reason. It's just a combination of fear or the lawyers backtracking a little bit on how strong they suddenly feel or not feel about it because the evidence has changed a little bit. So in terms of your personal experience, that's pretty awful, to be honest. Also, you got my sympathy with that. That's in my experience is not particularly common. Is that the vast majority do settle. Interesting you use the word that or the phrase that both sides feel like they've lost, is that a couple of friends who are judges say exactly that. They say that I know I've given the right judgment if both walk out and they look a bit miffed it's because I've actually got it just about right between the two. And mediations are a little bit like that. I always speak to my clients the next day, because next day I know they're feeling like that maybe they gave a little bit too much, and both sides will feel like that. And that's unfortunately the nature of compromise, isn't it? Is that but the alternative is what you experience, which is then another 2, 3, 4, 5, 6 years of upset, emotional involvement, litigation, that feeling in your stomach, isn't it, when you wake up in the morning, where you've got that kind of knot in your stomach, you can't work out.
Absolutely.
It's that. I remember. Yeah. In fact, it's so poor. I'll be completely transparent, is that I separated from my previous firm on the basis I just handed back my shares in the end. You know, I owned a third of the company because I just couldn't stand the fight, because I looked at it and went, not because I'm shy about having a fight, but actually the amount of energy it was burning through, never mind time and lawyer's fees. I just took the view, do you know what, I can use that better somewhere else. And in fact, within a year, we've made up the difference and beyond at this firm, because it was good, focused energy. We were putting it into the business rather than on the fight. So you have my sympathy, Paul. I think you've had a rough experience.
So as you and I get to know each other better, I could tell a very similar tale to yours there about making a pragmatic decision, which, as every day that's gone on since has looked like a brilliant one. Before we get on to your second track today, just interested in again, from my point of view, it's a fascinating area. So I say I've been involved in a lot of disputes with clients over the years, and I always remember a barrister saying to me, no matter how strong you think your case is, even in sort of, nearly near perfect situations, because of the human side of law, shall we say, so the ability of, so for instance, what was ridiculous about my situation with the lady I was talking about, everyone knew that she would completely break down in court. So to some extent, what I was having to do was to put on my big boy's trousers and say, look, this is just posturing. This woman will not allow this to go to court. But of course, when you've got, a real flesh and blood person and someone's asking you for a lot of money, it's easier said than done. Yeah. But so for the very reasons, obviously you've got the human factor. So in this particular case, this woman probably would have underrepresented herself, whereas I, as a good speaker, brave sort of person who's telling the truth as well, which helps, I would have done a very good job. But nonetheless, the barrister said to me he would never advise anyone that they had a better than 75% chance. Do you think that's fair or unreasonably pessimistic?
I don't think it's far away from probably where I would put it. I was going to say 80%, to be honest. In every case, no matter how strong you think it is, when barristers giving you that, invariably that's a trial risk. So what they're saying is, on the merits, on the papers, we think you've got a very, very strong case, you're going to succeed. As soon as you introduce a court environment, is that you are then open to the risk of whatever the judge decides he or she likes or doesn't like, what evidence pops up, how people perform in the witness box. And that's why you'll always find the barrister sort of hedging a little bit, because they'll say, look, it doesn't matter what I do, how good your case is, we don't know how people are going to perform. And perhaps more importantly, we've no idea how the judge is going to see it. Because, of course, they do their best, but they bring themselves to every judgment. I don't see how you can do anything else, is that you bring yourself to a case and they will make a judgment based that they think is right. And I've had, in fact, I can think of 2 trials where we haven't succeeded. We succeeded in every one of them in my entire career. And in both cases, I assessed us at 80% chance of success. And perhaps more telling, the other side assessed their case at 20% chance of success, but their instructions were to let's have a go anyway. So both sides assessed it at 80-20 in the right proportions and the right size. And in both cases, the 20% the judge found in favour. And that's the risk they're talking about. I mean, one was about witnessing of a will, which to this day, the judge assumed that just because these 2 people, to have an effective will, you have to have two witnesses to it. And they need to be jointly present as the person who's signed. And this particular judge decided that even though they were in separate rooms, if one leaned back, one leaned forward, there was a sight line, and therefore it was okay. And we had models showing that couldn't happen, but the judge had just decided that this will needs to stand.
Okay.
And we're going to find in favour. And that's what they did.
So, Owl City and Fireflies. I've never heard of Owl City. So what's good about this track then, Martin?
Well, this one is I've got something I only found out later in life, a condition called aphantasia, which is essentially When you close your eyes, if you try and imagine a picture, say if you try and imagine the face of your child or your wife in your mind's eyes, I can't see anything. It's just completely blank. And I didn't even know I had this in my late 40s and heard it on a radio station like this one. And I sort of carried out the test and thought, blimey, I was very upset for a couple of days, thinking, how can everybody see this and I can't? And then I realised, well, have a word with yourself. You've had it for 45 years and you're fine. Yeah. And what this track brings actually for me is it's a track full of wonder and awe. And one of the positive things about aphantasia is that I literally get in the car and drive in the morning, and as you're driving to work or wherever you're going, it's like you're seeing it for the first time again. It's great. Because I don't imagine it, so you get this kind of wonder and awe, which is fantastic. And this really captures it for me. And it's Fireflies by Owl City. Yeah.
This is Full Weight on Aspen Waite Radio.
It was Fireflies by Owl City. I do know that song actually, Martin. It just once it started, I thought, I know this.
Yeah.
Right. Yeah. We've only got about 12 minutes of talking left, and it's obviously only right as I've got you on that we ought to talk about your business and how people can avail themselves of your services. So we'll jump on a bit. So you formed your own business, IDR Law, in 2017. What is IDR? R stands for resolution or something, does it?
It does indeed. It's inheritance dispute resolution.
Oh, okay.
So it starts as it means to go on. We do try and get things sorted without trials and litigation if we can help it. So yeah, but it's all
one
we
of the
do.
things.
In fact,
go on.
No, sorry, I was going to say it was. We're the only firm still in the entire country actually that just does this work and nothing else.
Yeah, I was going to say that.
As a result, we plug into most of our work comes from other law firms or the will write. Anybody in the sort of probate world sort of passes stuff through to us usually.
One thing very interesting about your staff profile is it seems to be exclusively female. So how did you manage that? Is that a reflection on the labour market in Harrogate?
Well, do you know what I did when I set this? When I set it up 4 years ago, this is pre-pandemic. Remember, I set it up on the basis of a virtual office. So we do have this nice physical space. We just opened one in Manchester. In fact, we're coming down to Bristol in the new year. So we're having these sort of nice central hubs. But I was looking for the people, finding good quality contentious probate lawyers who are fit our personality types, that are very pro-family, pro-mediation, get things done. It's quite difficult. They're spread all over the country. So I set the practice up virtually and they all plug in. What I found as a result is that a lot of these seem to be, there was a predominantly female sort of split in terms of contentious probate lawyers. And because I wanted experienced ones that were sort of 10 years qualified and beyond, invariably they were mums and had small children. And like we expressed to my wife, is that, and to create a firm that enabled them to work, we had to design something called Family Flex. So we created a working environment that meant we agreed a number of hours a week, but then you work it however you want on whatever day you want, and we pay overtime when you're doing it. So we created something completely new within the family law, in fact law, to be honest, market by actually flexing around families. And of course, then when the pandemic hit, it didn't affect us at all. Everybody just carried on exactly as they were until the pingdemic, of course, has now hit, and that is causing problems. But as far as that, and that's what happened. So we've got probably 6 or 7 really qualified, excellent family lawyers who can look after people with contentious probate, but they're flexing from home. So as a result, that's how it came about. So in answer, yes, predominantly there is a female grouping, certainly more females doing contentious probate than males by some distance, but actually we built it to attract that quality by providing the flexibility. And that's worked incredibly well, I have to say.
Okay, without stating the obvious, so how do contentious probate cases arise? What are the underlying circumstances which give rise to the potential for a contentious probate situation?
I think what might help is just take a slight step back and say that a couple of stats that I think are pretty telling, and you'll see where it goes, is that recent research shows that £5.5 trillion is going to be passing in the 40 years ending 2047. That's £5.5 trillion. That is more money that's ever passed from the oldest generation to the next generation ever in history. You've got that combined with 1 in 3 people now are relying on an inheritance to either pay off debt, pay off a mortgage, or fund retirement. That's 1 in 3. Wow. So 1 in 4 are now saying that if I don't get what I'm relying upon, I'll have no alternatives to bring a claim. So no surprise that someone described it as a perfect storm for contentious probate litigation. It's absolutely right. You bring into the mix then the fact that we've got more blended families, as the Americans call it, with second marriages, with stepchildren, half children, etc., than ever before. You've got people living longer. You've got dementia rates going up, and you've got what we talked about before. You've got a more litigious society. 1 in 4 will bring a claim. And then you've got at the bottom of this, you've got 2/3 of people still having no estate planning, will, lasting powers of attorney, funeral plans, life plans. They haven't got this organised. So you've got this disorganised death that's happening more and more and more and more. And of course, the problem then is that what happens when somebody dies without a will is that something called the intestacy rules kick in, and they're very strict, very draconian. And again, they're quite old. They don't take into account, for example, cohabitees. You can be living together for 30 years. You will be ignored. They don't take into account children that are natural children. So that, again, they are ignored. So you get this situation where it doesn't work. So if you don't have planning in place, with that amount of money passing through this generation, there is no surprise that these claims are coming through. So again, no surprise that's going to happen, Paul.
Well, yeah, it's interesting. Yeah, interesting thought comes to my mind here. So how is it we've created a society where, I mean, you know, one thing that the English legal system is supposed to do is to create relative fairness, isn't it? Sort of, you know, an even playing field, you know, a level, you know, set of rules, etc. So, you know, how can it be? A case I always put forward, actually, is a hero of mine, Admiral Nelson. Was obviously his woman was Emma Hamilton. And he made it quite clear I'm not sure if he had a will but he actually sat down with his friends. He had written material about this. He made it quite clear, you know, what he wanted to happen to her in the event that he wasn't around. And then, of course, as soon as he died, she wasn't even invited to the funeral. And she ended up dying in abject poverty, for instance, because his wishes were not carried out. So that's quite a good case. So how can it be we have a society where, I don't know, a man lives with a woman, as you say, maybe for 50 years. You know, they are incredibly closer than maybe any husband and wife ever are, or, you know, they have children which are illegitimate. Why is the law throwing those people away, and yet it's almost going to ridiculous extents to protect ethnic minorities, transgender people, for instance? You know, what sort of world have we created?
Oh, well, I think we harped on it earlier, is that the whole statute basis for wills and dealing with wills and how we pass to the next generation goes back to 1837. It's a very Victorian kind of construct. You've gone even earlier than that, but certainly the Englishman and his castle kind of idea cropped up into the Victorian time. And we have people living on their inheritance to come back in the Victorian time. So this is not new, people living beyond their means. But insofar as trying to remedy it, there was a big move in the sort of early 70s. You'll remember from your legal reading a chap called Lord Denning, and Denning was somebody who was a real champion of women. And at round about that time, there was an act that came into force, 1975, called the Inheritance Provision for Family Independence Act. And what this act does is it works against the injustice of unfair provision in wills. So, but prior to 1975, you couldn't do anything about it. You know, whatever you left, you can leave your spouse out, never mind your cohabiting. And we couldn't do anything about it. But from 1975 onwards, there's been a push back. And as a result, there are certain groups of people, the ones that you've actually already listed, the cohabitees, the children, the financial dependents, who can actually bring claims against either a will or intestacy to actually vary the provisions of what they will receive unless the court intervenes. So there is a pushback, and it's gone, as all these things, sometimes the pendulum goes a little bit too far. So you've got people complaining about the fact that adult children who are financially dependent, I should be able to cut them out of my will. But of course, this act allows them to bring claims, not always successfully, but it gives them the right to come back. So there is this pushback, and it does work to some extent. It's that anybody that we've seen who we know are in that group that you are describing, invariably we will be able to get something for them in terms of reasonable financial provision. So there is that cross-check in place, and it is in statute, and there is common law that helps as well.
So just to be clear, so do contentious probate cases arise out of situations where the deceased has left a will or hasn't left a will? Which is more common?
The one that's more common is, I would say, probably the latter, in that they haven't left a will. And the reason for that is simply that more people have no will than they do have a will. That's just simple maths, really, is that So you've got 65% of people with no will in place. And in fact, that's really what the other business I've set up to run is trying to combat, is that we've set an online service called FRisk, or Family Risk Report. And the idea behind that is that I'm a huge believer, if you educate people to understand the effect of dying without a will and without testamentary planning in place, then most of us will take some kind of step. When I do lectures and tours and ask the room, how many of you got will in place? A third of them will stick their hands up. But how many of you got children? Most of them stick their hands up. Well, there's a disconnect here. You need to start sorting things out. So what FRisk does actually is that you drop on the site, you put in some basic details about your family, basic details about your finances, and then it produces a report that summarizes everything that will happen to everything you care about if you died yesterday. So if you'd have died yesterday, this is where it all goes. How much tax you pay, who's in, who's out, who can bring claims, who can't bring claims, what about your digital assets, all those kind of things are spelt out right in front of you with a score. And the idea and the hope is that creates some kind of urgency to say, blimey, I better fix that. And you press the button and it takes you away to somebody who will then sort you out with a will and LPA, that type of stuff. So this is, for me, I've got a bit of a tech interest, is trying to use tech to help avoid probate disputes in life. And that can be done. The best way to try and avoid disputes is to have the conversations in life, get your will sorted out, and actually then speak to your family. Talk.
Why do you think that so many people, including, quite, I should probably sounds a bit intelligent people or even business people, why is it that they are failing to plan for their, for the future of their loved ones, for instance? Why do you think that is?
I've done a survey on this, in fact, and the short answer, you'd be amazed by some of the responses, is that the one that's consistent is I'm just too busy to get around to do it. So I'm too busy. There are certain categories that say, they actually say to me, I'm too busy to die. I won't die. It's somebody else's problem. I won't have to do it. There are some that will shy away from it because they know it will start a conversation within the family that they feel uncomfortably having. So they avoid it. There are some that say, and these are the hardest to reach, who simply say, I'll be dead, so what does it matter? It's not my problem. And again, the last one, I suppose, is that there's a fear of, or a misunderstanding as to exactly what it is will happen without a will. Most people still believe that if I'm living with somebody for 20 years, there's a notion of something called a common law wife, which doesn't exist, as you know, but is that it will all pass to that individual anyway, which of course is not correct. And then there's a fear of lawyers. We talked right at the beginning of when we were speaking this morning, is this fear of it's going to cost me too much, it's going to be too difficult. So it's a combination of all those things. But the one thing we can guarantee, of course, is death and taxes. Is that those two things
as Disraeli said that to me or something. I can't remember who it was.
Yep.
Why are you waving at me, Drew?
6 seconds, sir.
6 seconds. What do you mean? Sorry. So we're going to play. We're going to play the track at 10 o'clock. Okay.
Okay.
Sorry about that.
No, don't worry.
No, I think so. We tend to be so. It's really interesting debate. So I don't want to cut you off. So we're fortunate in time we've only got station music playing at 10. So we're going to carry on. Is that all right with you, sir? Yeah, good. Well. So interrupting my interview. I wonder as well whether people are put off having a will because it makes them confront their death. If that makes sense. Think that's true?
I think it is true. In fact, I've acted on estates where individuals were in dangerous pursuit sports, whether it be sort of TT racing or others, where actually the superstition is that as soon as you make a will, you're going to die. And it's ridiculous, really. But it's absolutely, people get absolutely fixated on that. And it's a subject matter that nobody really wants to talk about. None of us do. But it's a conversation better had in the light of the morning sun, isn't it, rather than late in the day. And I think the other thing I would share from the other side is that from a contentious probate point of view, there's not one dispute I've dealt with where somebody hasn't turned around and said, oh, blimey, if only my dad or my mum had organised it, we wouldn't be here, would we? No, you wouldn't. You wouldn't be here. Is that they could have organised it. So do it for your kids. If you can't do it for anybody else, do it for your kids.
Yeah, I suppose the story you're painting doesn't say an awful lot as good about people, really, does it? I don't care what happens to my wife, or I don't care what happens to my children. I don't care what mess, and of course you and I know the reality can be years of crap,
No, it's right. I think it's a small minority, to be fair, Paul, that actually say, I don't care, I won't be here. That was, of the survey, that was by far the smallest response. The biggest response was twofold, really, is that one saying, I didn't know, I had to do that. And secondly is that I was just too scared to talk about it. I was too scared to get involved and do it. Followed by I'm too busy. So they tend to be the three main reasons. So I don't think, society is still pretty good. And my experience of the human condition is that most of us want to do the right thing by our family. But with blended families and the complications of life as it now is, it's not as easy perhaps as it once was.
So what can we do to improve this situation in the last minute we have?
Well, I think this is why we developed FRisk. It's a free report. You land on the site, and it starts with knowledge. It starts with information. It starts with knowing and understanding what your death will have an impact, how it will have an impact on those that you love and care about.
But the person still has to have the motivation to go on the site in the first place, don't they?
Yeah, it does. Yeah, absolutely right. And this is why we back it up with editorial. So we're trying to get this message out. It's trying to get this momentum, this mortality momentum going. You'd think in a pandemic, we've seen a slight increase in those people giving some thought to what if. But not, and this battle of getting people to do wills has been running for decades and decades. It's still at just over 60% without one. We're trying to get it down to a 50% figure, but all we can do is educate and get into people's faces and say, look at this, this is you, this is what happens to you, not some other story. This is your family story, this is your risk score.
Okay.
Get it fixed.
Right, Martin, you're the first guest I've had, or the 7th guest I've had, and you're the first one where we've talked up to 10 o'clock, and your third song is going to be played afterwards. So not quite sure what that says about either of us. So thank you ever so much for being such a great guest today. Look forward to getting to know you better. And if listeners are motivated to do anything after listening to this, then get in touch with us on Aspen Waite Radio. So thanks, Martin, again.
Thank you again. Thanks for the
invite.
This
is Martin's final track, which is The Weekend.
Online, on DAB, and on the Aspen Waite Radio app. This is Aspen Waite Radio News.